Good afternoon, everyone. Welcome to the HospitalityLawyer.com Hospitality Law Seminar Series. Today's topic, legal and risk challenges in contract food service management. Today is December 8th, 2021. We've got a terrific lineup of thought leaders focusing on labor and employment challenges, the food service contract management, and that pesky item and commodity known as alcohol. And we're going to get right to it. For those of you real quickly that need CLE credit or looking for CLE credit, we will put up a very quick survey at the conclusion of each speaker's remarks, just a simple yes or no, and we will be sure to get you in the pipeline for that CLE. Joining us today, Jason Geller, Fisher and Phillips, Greg Duff, Foster Garvey, Alexis Mason, Gray Robinson. And with that, let's get started. We're going to begin on the labor employment side. Joining us today is the regional managing partner for the Fisher Phillips law firm based in San Francisco, California, is Jason Geller. Jason in his practice represents employers and along with his firm has a national practice throughout the United States, representing employers in all aspects of labor and employment challenges, including collective bargaining, employment contracts, management agreements, etc. Ladies and gentlemen, let's hear what Jason has to talk to us about today. And we're relatively looking at the end of the pandemic, but we're not quite sure. So with that caveat, take it away, Jason.
Stephen, thanks so much for that very kind and generous introduction, and thank you for having me today. Good morning, everybody. I'm Jason Geller with Fisher Phillips in San Francisco, California, and we're going to talk about the interactive process and accommodating employees in the age of the pandemic and hopefully on the other side of it. And if we get started, one issue that we need to be concerned about, of course, is complying with the Americans with Disabilities Act and any applicable state law. I mentioned on the slide the Fair Employment and Housing Act, or FEHA, although I'm not going to confine the presentation today to California issues, notwithstanding my slant in that direction, given where I'm sitting. In addition, other issues that come up in the interactive process would be addressing employees who make requests for leaves of absence under federal or state law. And then, of course, in the food service sector, we're well aware of mod rates and industrial or alleged industrial injuries, and workers' compensation laws often come into play. And in my experience as both a litigator on behalf of employers and as one who counsels companies to keep them out of court, I can tell you that these issues are some of the most common that get litigated in federal and state courts across the country, and certainly here in California. So it's critical that as hospitality employers, we approach these situations methodically and with an eye toward mitigating risk. And that's hopefully an objective we'll accomplish in part today. Let's start off with staying calm, easing into the interactive process. The interactive process is critical and probably the most essential aspect of dealing with employees in the disability arena. I am going to talk generally here for a few moments about the interactive process and some important principles that I want to underscore and hopefully reinforce for everybody. Most of us are probably quite familiar with them. And I am going to then attempt to address the impact that COVID has had on this process and some issue spotting in that regard. The interactive process, at least out here in California, can in and of itself support a legal theory of potential liability against a hospitality employer in court. And what I mean by that is often out here, employees, when they sue for an alleged wrongdoing in the disability context, they'll usually bring 4 separate grounds for liability, alleged liability, including, of course, discrimination, but also separately failure to engage in the interactive process. So I just want to mention that only because as an employer, you could win in court on 3 of the 4 disability related types of theories, but lose because you failed to engage in this process. So this is really critical. And as I mentioned in the slide, it's got to be prompt and in good faith. And what that means is the employer wants to have evidence that it legitimately and promptly was considering the requests that the employee made to be accommodated. Even if you know at the end of the day, you're going to conclude that the accommodations are not going to be reasonable or there's going to be a defense to providing them, you want to make sure you go through the process and document it well so that you can use it in defense of potentially later claims, God forbid, should that come to pass. The employer has many, I shouldn't say many, but 2 main grounds to refuse an accommodation. And one that I've mentioned here is the undue hardship defense. The long and the short of it on this, folks, is that if you're going to deny an accommodation based solely on expense, it better be a significant expense relative to your resources. I usually recommend that clients stay away from relying entirely on expense, but instead take a look at how the accommodation might impact the operations of the business and cause other practical difficulties, because those are also grounds to support the undue hardship defense, which, needless to say, it's a defense. That means we as employers need to prove it, and it's not easy to prove. Another defense, which I'm going to touch on momentarily, is the direct threat defense. I call it a defense, and that's where the employer argues that we cannot provide the accommodation because it would create a direct threat to the health and safety of the employee or others. More on that to come in a moment. So the interactive process begins with, you're really going to target 3 main types of questions in the process. The first is you're entitled to determine whether the employee in fact has a protected disability. Remember that if they don't have a disability, the employee isn't entitled to the protections of state or federal law in this area. And so the threshold question in the COVID arena is, well, is COVID a disability? A lot depends on what state you're in. In California, I can tell you that the definition of disability is very broad. It's a low bar. And under the federal standard, the disability is a physical or mental impairment that substantially limits a major life activity of the employee. In California, we don't have the substantially limits burden. It's much lower. It just limits a major life activity. And the law defines that to mean makes doing your daily acts more difficult. So the question is COVID a disability? Generally speaking, although the law does say that temporary conditions can be considered a protected disability, for the most part, temporary illnesses like the flu, a cold, pneumonia, something that is isolated and comes and goes in a very short period of time, generally will not be protected. But there is plenty of case law that says a temporary condition that morphs into something longer may be protected. So where does COVID lie? Certainly a short-term COVID illness, in my view, and I haven't seen any authority to the contrary, would be outside the scope of the protection of the disability laws. But what about long COVID? I think there you're certainly confronted with a likely protected disability. And long COVID, and it can vary from 2 months to a year. I had a situation very recently where we had an employee with long COVID and we engaged in the interactive process. So I think you're going to need to see about the duration of the condition and whether there are any other complications from it to see if they meet this threshold question. The next two pieces of the interactive process that you get into, of course, are what are the employee's abilities to do the essential job functions, whether the employee is requesting any accommodations or whether the employer is going to suggest any of its own. Those are the three big components of what you hope to achieve from this process. And ultimately, when we're dealing with contractors and staffing firms, who's responsible? And it's really a collective responsibility. Now, I think it's risky for the special employer to place that burden entirely on the staffing firm. So if you have a situation where you've got an employee hired through a staffing firm who is disabled and is seeking an accommodation, that interactive process can be collective, much like we see in part under the FMLA and some state leave laws. So if we drill down a little further into this, I have a 5-step process that I outline in the interactive process. And I'm not going to read the slides to everybody. You'll get a copy of the deck and you can look at them yourselves. I want to highlight a couple key points. Number 2 in step 3, just for starters, if an employee in the interactive process explains what the accommodations are, but does so cryptically, you don't understand what they're asking for, their writing is illegible or what have you, it is incumbent, it's critical that you have a written record of making an effort to understand what those accommodations are. I can recall a case I litigated not very long ago where that was a big theme of the plaintiff's attorney, that we didn't do enough to appreciate and understand the accommodation sought. So you really need to make sure you understand it. Don't overreach and overdo it where it looks like you're hammering and battering the employee. It's got to be legit. If you don't understand, make it clear. Moving to step 1, of course, to backtrack, very critical that we acknowledge the request for the accommodation in writing and promptly, and then get ready for the meeting or the written communication on the topic. By the way, oftentimes the interactive process should include some verbal or in-person discussions to ensure that we understand the limitations. The other point I want to mention here is part of step 3, and I'm not going to cover all of the items, but I do want to emphasize this 100% healed type theory. In California, there's a regulation that says you can't tell somebody, don't come back until you're 100% ready. It also says that leaves of absence are accommodations of last resort. So here, you want to be careful not to step in it, as they say, and make statements that suggest you expect a person who's 100% ready to roll before you'll let them back into work. Instead, they need to stay on a leave. That can become a problem. So really, before you consider a leave, please be sure that you have explored other alternatives to keep them in the job in some aspect. The last step I want to mention is repetition. This is an ongoing process. It doesn't begin and end one time. You got to keep track of the evolution of the employee's conditions. When are you done? Well, when the employee tells you, I'm done, I don't need any further accommodations, or it's successful, where you roll out an accommodation and it effectively assists the employee in doing the job. Now, one thing I want to mention about that, and this is important in the COVID realm, an accommodation, or if I take a step back, a reasonable accommodation is intended to assist somebody in performing the essential job functions. So if somebody says to you, for example, I cannot work on site because I've got a condition that makes me hyper vulnerable to COVID, and my doctor has precluded me from working on site for that reason. I'm too high risk. Well, in that situation, and this is a buzzword here in California, potentially you could claim that the employee is no longer a qualified individual. That means that the employee is no longer capable of doing the main job functions with or without a reasonable accommodation. And this is quite common where on-site work is an essential job function. We know in food service that it is. Now, there may be positions where telework is appropriate. If you're a manager, and that's even probably a stretch, there may be some other position that would not lend itself or require on-site work. You'll have to consider that. But clearly, that type of situation would render someone not a qualified individual. The other thing I want to mention here before we drill down into direct threat is whether the employee fails to cooperate. You want to be sure that you're asking the right questions, soliciting the necessary information. If you don't get the necessary information from the employee, well, how long do you expect your COVID to last? When do you think you're going to be returning to work? If you're not getting answers that are prompt, that are complete and legible and comprehensible, you may then take the position that you, employee, have not interacted with us. We're ending the interactive process. If you don't come to work, we're going to have another conversation. So, of course, that's something that you want to discuss with your HR teams and your employment counsel, but it is incumbent on both sides to participate. So let's talk a little bit about types of accommodations. There are no exhaustive lists of potential reasonable accommodations. I list a few of them up here that are common. A couple principles to remember. If somebody tells you, I can't come to work, I've got COVID, it's long COVID, and I need to have my food service job, the aspects of communicating with guests and serving food eliminated, make me an office person. Well, that is not a reasonable accommodation under a job restructuring scenario. And why? The reason is the law says you do not have to strip essential functions of the job to make an accommodation. If it's a peripheral function, that's another matter. Job transfer can be a potential accommodation if the person is qualified. And of course, I mentioned leaves of absence, which need to be finite, not indefinite. And that's where in the long COVID environment, that may be realistic as long as you know and have received some objective information from the employee and his or her doctor that a finite leave is likely to get somebody back to work. If it goes on and on and on, it ceases to be effective. It is no longer a reasonable accommodation. And considerable law, certainly in California, and I would hazard to say across the country, would say that indefinite leaves are not required. Now, teleworking, really not an issue in our space, in the food service space, as I said, unless we have an employee who can perform the essential functions remotely. The law, by the way, has indicated that, and I would say this take it with a grain of salt, just because we were all forced to remote work in COVID doesn't set a precedent in the future. Do I really believe that? I don't know. We'll have to see where the courts are going, because certainly if we made it work and everything got done, is it really going to be precedential in that I'm going to now be obligated to seriously allow remote work when prior to the pandemic, that would have been out of the question. Now, obviously in food service, like I said, on-site work in many roles will be an essential function. So in the COVID space, and I'll conclude with points about direct threat. As I said, direct threat is a defense to a request for an accommodation. What does direct threat mean? Well, it means that the employer has objective medical evidence that supports its conclusion that I can't have this person come to work, excuse me, because they may create a risk of substantial harm to others, the public, guests in our facility, or other employees. And so this certainly, if somebody has COVID, they're going to be excluded from the workplace. But what if they have some other type of condition unrelated to COVID and they want to come back to work? If in the COVID space, we have certainly the objective medical evidence to say, if you've got long COVID and you're telling us you want to come back to work, you can socially distance, you can wear a mask, etc. Well, we've got objective medical evidence in the view of many, not all, but in the view of many, that from the CDC, Dr. Fauci, whoever, local health authorities, that say that it is a highly transmissible disease and that vaccines are very effective in limiting or eliminating potentially transmission. So that's something where you could rely on that public health documents for the objective medical evidence. You can also look at your own practical experience. We've had a lot of outbreaks of COVID. People need to work closely in a kitchen together in a hot environment. They're touching each other, moving back and forth. You're exposed to the public, etc. So these are things that are real that you can rely on to support the defense of direct threat should you have somebody who's sick and wants to return. With that, I will conclude my speaking portion of the presentation, and I'm happy to entertain any questions in the remaining time. And Stephen, thank you very much.
Hey, Jason, that was terrific. Thank you. Very insightful information. Great suggestions as well. Thank you for that. Ladies and gentlemen, I want to be sure that, first of all, you, as Jason points out here on this slide, you can subscribe to their newsletter, but you definitely want to visit FisherPhillips.com. They have an extraordinary library of information, not just about COVID, but around all aspects of labor and employment challenges that you face as an employer. I encourage you to spend some time on their website. You'll find it very beneficial. Jason, so I wanted to talk about the website, but I also want to ask, I want to make it clear, you made such a good point about on-site work being an essential function of the job. How crucial is it in your mind that employers go back to their job descriptions where they're listing the essential functions and add the fact that on-site work specifically is an essential function of the job?
Stephen, I'd highly recommend that. And in general, the job description, I realize we didn't talk about those. The job description is critical, not only in accommodation, for accommodation purposes, but for a lot of other purposes, performance management and the like. But you would want to do that. And you'd also want to identify, among other things, what are the essential functions, and then what are the peripheral functions, and what are the physical requirements of the job, among other things. But that is very important. Up-to-date job descriptions are the first place that a judge or a jury is going to go when it comes to accommodation cases.
Yeah, I think that's a great point. I've always said, Jason, also in those descriptions, we should also include the word safely. In other words, the expectation that you will perform this job safely. I think that we just set that expectation from the beginning. Okay, listen, you talked about something else that I want to get back to, which were staffing agreements. You know, with the labor shortages, a lot of people are turning to staffing companies. Can you walk us through, just from your experience, a few of the not necessarily the pitfalls, but things we want to be mindful of from the hiring side, right? Those of us hiring the staffing group to come in. What do we want to think about those contracts and looking ahead with those?
Sure. And I would say the first thing from the hiring perspective, I would say, is understand who your partner is. Do your due diligence to assure yourself that this staffing firm is reputable, they have good practices for wage and hour and employment compliance. I'm not saying that you got to kick the tires repeatedly, but you want to make sure you understand who you're working with. And the reason for that is really twofold. One, in California, I can say, and this may be true in other jurisdictions or states, we have a labor code provision that makes staffing firms and their special employer clients jointly liable for wage and hour violations. So, and we know when we hire a staffing firm, they are usually managing, I hope, the timekeeping, paying the employees, having the correct pay stubs, wage statements, and the like, making sure the right rates of pay are being paid, et cetera. And you as the hiring company do not want to be liable for their miscues. So we have a statute on the books to that effect. Secondly, the other reason is that we have factually joint employment scenarios where employees can argue that notwithstanding express joint liability, which I just said, but other issues factually that, oh, well, both the hiring company and the staffing firm were controlling the daily activities of this employee, and therefore they should both be collectively liable. So you really want to understand who you're doing business with. Secondly, look at your agreements. Understand, for the reasons I just mentioned, that there is potential joint exposure. You want to have a good indemnity provision there, meaning you're going to ask that the staffing firm indemnify and defend your company should there be any litigation arising out of their own miscues. Secondly, in the agreement, spell out who's going to be controlling the daily activities of the employee. Shift as much of that to the staffing firm to the extent possible, including fielding complaints of alleged discrimination or harassment. To the extent you start getting involved in responding to staffers' complaints of harassment and discrimination, that can walk you right into a potential joint employer situation. So you really want to have the agreement address how those things are going to be handled. Thirdly, and lastly on this, in the interest of time, I would say, make sure that you have good practices that are consistent with the agreement. In other words, when you have somebody come to you and say, oh, I want to complain about sexual harassment by so-and-so, you're going to need to decide whether that's the type of complaint that needs to be run through the staffing firm first before you decide to inject yourself, or make sure that you're not weighing in on, for example, compensation decisions and performance decisions of a staffer. I don't know why you would want to do that, but I've seen it happen by hiring companies. Things like that suggest control, and that can lead to joint employment, which we're trying to avoid.
That's very interesting and very helpful. Thanks, Jason. Look, finally, just have a couple of minutes left, though. You work with so many employers, and with the labor shortage that we've mentioned, where are you finding that these folks, they're trying to be creative, I'm sure. Where are they looking and potentially having success in filling some of these vacancies that they have?
That's, excuse me, really a challenge, Stephen. And I do see a lot of firms looking to staffing companies for the reasons you mentioned. I think that they're revisiting practically, and I'm not always in the weeds on their recruiting tactics, but I see them often talking to former employees, even pre-pandemic, reaching out to those folks. I also see them, and by the way, I should just mention, there are right to recall laws out there. We've got them in California on the local level and the state level, which obligate employers who laid somebody off in the pandemic to give give notice to those employees when a job remains open again, and giving them an opportunity of right to first refusal to get that job. So there are compulsory reasons why they are reaching out to former employees. So I see a lot of that. And I also see employers also considering hiring older workers, where workers in their 50s, 60s, and 70s who are still interested in working and have proven to be quite productive. It's beyond the disability realm, I realize, but that has been a favorable outcome in my experience.
Yeah, and for those folks that you just mentioned at the older edge, as they're also looking for that socialization, which on-premise work can provide, you know, assuming we can do it safely, vaccines, et cetera. But yeah, listen, that's great. Well, that takes us to the end of our time, Jason. I can't thank you enough on behalf of HospitalityLawyer.com and audience. Thank you so much. As always, very fascinating information. We really appreciate it.
Thank you, Stephen. I appreciate it very much. Have a good day, everybody.
Likewise, Jason, if I can remind you to stop sharing your screen. And for those of you that are interested in CLE, please hit the yes button and submit. And then we're going to move into our next speaker, Mr. Greg Duff. Greg, out of the Seattle, Washington office, is a principal Foster Garvey. But don't let that Seattle, Washington fool you. Greg has a national practice as well. Businesses hire Greg all over the US for his expertise in hospitality, travel, and tourism. Greg's practice actually focuses on hotels, restaurants, tour operators, cruise companies, airlines, and industry associations. He has over 23 years of lodging industry experience, including in-house roles with Starwood, Webvan.com, and Columbia Hospitality. From my personal experience, ladies and gentlemen, there are very few lawyers that understand the breadth and scope of the industry that we work in. It's always a pleasure to have Greg join us. Today, he's going to be talking about Food Service Contracting 101. So for those of you that have been in it a while, this will be a terrific refresher. But for those of you that are just starting out in this aspect, it will be an outstanding orientation. Greg, take it away.
Morning, everyone. I'm going to switch over my screen here. All right. Let's start this from the beginning. Okay. Good morning, good afternoon, good evening, wherever you may be. Stephen, thank you very much for, again, allowing me to join you all this morning or afternoon and talk a little bit about food service contracting. As Stephen mentioned in the introduction, I come at this, I guess, subset, if you will, or segment of the industry, primarily from the traditional hospitality side of hotels, restaurants, cruise, et cetera. Our work in this space actually literally began, I would say, within the last 5 to 6 years, as many of our clients and or our clients' contacts started venturing into food service opportunities, which I'll explain a bit in a moment here, but essentially taking their skills and expertise and experiences and other more traditional hospitality or even lodging circumstances and applying it to contracted food service. So Stephen already mentioned our background and the firm's background is in fact national, and we do represent clients across the country, which at times gives us the opportunity to see what different clients may be doing in different parts of the country, and in this context, what employers or corporations or universities, et cetera, might be asking for. So it's been helpful to have such a broad practice. So let's dig right in here. So there are many different circumstances where food service contracting comes into play. There are many other opportunities or facilities or circumstances that it might apply other than those listed here. But I would say over the last 2 years or so, even during the high points of COVID, work was still being done in these areas. So one being obviously corporate headquarters, corporate campuses. What we have found is that as companies deal with some of the same labor issues that Stephen identified and Jason in the prior presentation, what we're finding is that many employers now, as they rethink what their office or corporate HQ or campuses environments look like, more and more are considering, should we provide other benefits to employees, either A, recognizing that they're only going to be on campus for a few days at a time and it will be concentrated time, we don't want them to leave, or as a recruiting tool. So we have a number of clients now that are in corporate campuses, corporate facilities, corporate meeting facilities that are providing these services. Number two is college and universities. If you've had a son or daughter looking at schools in the recent couple of years, you'll note that much ado is made about food service and what food service opportunities are available on campus. And so we're finding a lot of colleges and universities. Frankly, we've represented some college and universities that are looking to improve upon and diversify their offerings and bringing in just a variety of food service operators. The third is in arenas and sports venue. Many of these deals are very unique. They're done on a subcontract or a licensing basis. But obviously, if you follow sports at all, you'll know that there are arenas being built and constructed across this country, even throughout the pandemic. And many of them, too, are trying to compete on the basis of their food service offerings. So not only have we worked with food service management companies to take over the majority of those venues, but we've also represented a lot of our restaurant clients that have wanted to open an outlet within an arena or sports venue. And again, that relationship varies widely from simply a licensing relationship, in some instances, a subcontractor relationship, and then in others, a full-fledged management relationship. Finally, and one perhaps that has been in existence for some time is in the convention and conference center space. Obviously, these look and feel much more like a traditional lodging circumstance. Obviously, rooms are not involved, but many of the offerings, many of the facilities are very, very similar. Other facilities that haven't featured quite as prominently recently include healthcare facilities, both assisted living type facilities, or even hospitals themselves are now seeking to diversify their food service offerings. A lot of military installations, we've seen some clients go into those facilities, and again, in an effort to diversify and improve their food service offerings. And then recently, we've done a string of deals with some large airport remodels where they've wanted to bring in and outsource particular food concepts or food operators to come in and offer their food and beverage within the facility. So what I thought we would spend most, or that I would spend most of my time talking about today, is talking about some of the key terms that we find in nearly all food service agreement that we handle. And as I said before, these agreements and these facilities and operations do in fact have many elements that you might find in a traditional lodging type circumstance. Obviously, there's no rooms involved, but many of the terms, many of the issues are the same. And what I thought I would do here is try to focus on those that might be a little bit different for those of you that do have some experience in the accommodation world, and focus on those exclusive to food and beverage. The one thing I would say is that, these agreements represent sort of a combination of many different concepts that you might find, whether it be a simple management agreement, whether it might be a tenant landlord situation, whether it might be a catering agreement, whether it might be a sales agreement for food and beverage. All of those agreements have bits and pieces that make their way into these agreements. And at times when we've been asked to review agreements, it's interesting to see how people have many times taken an agreement from outside of the industry or outside the context and tried to make it fit here. And sometimes that's successful and sometimes not. So let's start with some of these key terms here. Facilities description, perhaps by its title, would seem obvious, but as you might imagine, depending on the facility or campus or circumstance, the facilities that are being asked to be managed, operated, licensed, or what have you can vary widely. In a number of deals we've done recently, the facilities traditionally, and again, there are so many exceptions, so I'm hesitant to say there's any sort of traditional description, but they often continue or contain F&B outlets. So whether it be an employee cafeteria, frankly, whether it be a guest or customer food and beverage outlet, there is typically at least one, sometimes more than one different outlets that are being asked to be operated and managed. Vending machines, believe it or not, many times there will be vending machines, and these aren't your traditional vending machines with soda or candy or what have you. Many of these vending machines will offer unique food offerings or beverage offerings that the contract food service provider is creating and providing. Catering tends to be a big part of these installations or instances, in that whether it be an in-house meeting that's occurring, whether it be an employee lunch that's held outside, whether even it be an offsite, many of these operators and managers are being asked to operate a catering type business to serve the facility's needs. Other instances which have been quite unique and frankly have raised issues that perhaps our next speaker is going to talk a little bit about is we have been part now of at least two instances, and these have both been in the corporate context, believe it or not, where the corporate entity or the employer organization wanted to actually open an on-site bar. We did the first of its kind here in the Northwest several years ago, and have since done a couple of them where literally there is an on-site bar. Beverages typically aren't available until late afternoon or evening, but nonetheless, they've opened the bar and has been a key selling point for recruiting and retention. So the services description, and obviously for those of you that are in commercial contracting, you understand the importance of getting a complete and accurate description of the services to be provided. These agreements tend to have some consistency among the services that are being contracted. One obviously being food service. That's why we're here today talking about food and beverage services. Many of them also include facility requirements. So just like in a management context, you might find for a restaurant or a hotel, there are certain expectations on the F&B operator or contractor to come in and manage certain aspects of the facility and maintain those. Typically, it is the same venues that are part of the facilities description. So whether it be outlets, whether it be catering facilities, whether it be kitchens, all of those typically fall within the purview of the food and beverage operator. Other issues that tend to come up in our services discussions include menu offerings. Many of the owner side parties have very, very specific ideas about what type of food and beverage they want offered in each of the facilities. So there may be certain subsets of food and beverage in one F&B outlet. There may be others in other types of outlets. And then in catering, there could be a completely different set of food and beverage offerings. Also, there's a lot of discussion typically around food quality, what type, the consistency of food, what kind of food offerings in the sense of gluten-free or other types of issues like that. And then there's also usually provisions that talk a little bit about pricing. We're going to talk a bit more about pricing issues when we talk about financial models, but many times there's a discussion about the prices that are expected to be charged to guests and customers and employees, and whether or not those types of charges would be subsidized in some way. Then depending on the facility owner, I'm seeing more and more now a discussion about where food and beverage supplies generally are being sourced. So obviously recognizing or leveraging the farm to table type concept, many facility owners now want certain commitments by the food and beverage operator as to where they will source their goods and produce and other things like that. But even some will go so far as identify specific farmers or dairies or what have you as to where they want those products purchased. So obviously, just like any sort of other management type relationship, there are instances and examples or circumstances where owner input and control is available. Obviously, this comes in and features prominently in discussions around finances. Depending on the financial or business model that is being employed, it can come in the forms of budget review, budget approval. It can be done around pricing. and other things like that. And as I said earlier, whether those prices are subsidized or not. Obviously, menu, as I said earlier, one of the issues that many of the owners care a lot about is in terms of what the menu offerings are. Also, as you see in other contexts or other management contexts, there is traditionally some input and control over staffing, particularly senior managers that may be at the facility, running the facility. Typically, the owner will want some review and approval of some of those key employees and want some say perhaps when one or more of them may be terminated. Depending on the owner, at times you'll also want or see owner input and control over work methods. And again, this could be as simple as sourcing. It could be in terms of what the variety of food offerings that are made available. And what we see in this instance is an incorporation, if you will, of what the employer's existing or companies' existing owner policies might be. And so whether it be recycling, whether it be farm to table, many of these companies or institutions or what have you have existing policies that they want to be reflected in the operation. And so from the food and beverage operator side, we often spend more time perhaps than we should trying to review all of these policies and procedures, many of which will be imposed upon our operation and the way in which the facility is handled. So equipment tends to be an area of discussion. Obviously, either the food and beverage operator could provide equipment or certain subsets of the equipment, or conversely, the facility owner could provide equipment. Those are obviously the two extremes of a spectrum, and there's just a multitude of combinations in between those two ends. Many times sort of fixtures and other type of equipment that you might find in a commercial kitchen are provided by the owner, and small wares and operating supplies and equipment may be brought in by the food and beverage operator. Traditionally, when there's either a new facility that's open or there is a transition that's occurring, at some point there is an inventory that is done traditionally and a clear identification about whose responsibility or who's responsible for what equipment, and then ensuring that everyone is on the same page as to who or what the owner may have contributed versus what the actual operator may have contributed. So term and termination, obviously important terms for any type of services agreement. In some instances, in other contexts, for example, in restaurant or hotel, you might see performance-based termination that's largely financially driven. The one thing that we find here is that because many of these operations are subsidized or expected to be subsidized, that financial performance may not be the best metric to judge performance. And so what we often spend a lot of time doing is trying to come up with more subjective standards, which obviously from a lawyer's perspective, the idea is probably scary to everyone. But we try to describe other types of metrics or measurements to judge the performance. Many times those are done in the form of employee or guest or customer surveys that are done. And then obviously the standard requires a certain level of performance or a certain level of survey response in order to maintain the contract. So this is an area, unfortunately, where sometimes we can get caught up in hard to define, hard to describe, and very hard to draft various standards. This is one area where I have found, and today I use often a number of food and beverage consultants, and whether my client has those in-house, which if they're an established operator, they likely do. But many times if I'm working with an owner of a facility, I will recommend that we bring in an F&B consultant, some of which I have worked with that have retired from or left big restaurant companies or have left large corporations and ran their corporate food and beverage programs. But those individuals, having sort of lived and breathed these scenarios, are typically very helpful in trying to come up with appropriate metrics, appropriate standards to judge the performance under the contract. And then they also tend to play an important role in the financial models, which we'll talk about here in a moment. So representations and warranties, obviously every good contract has some of the unique things that we find in food and beverage include obviously particular attention around licensing and certifications for food service. Obviously, alcohol, which we're going to hear a little bit more about here shortly, is important depending on whether or not alcoholic beverages will be made available. I also now tend to focus on food safety and food sourcing rep and warranties. Facility owners tend to be very focused on those items to ensure that the food and beverage products are fresh and free of viruses or what have you. We tend to spend a lot of time thinking about those things depending on the likely menu offerings. Finally, one that actually you might not expect to be as prominent, but I think in literally every deal we've done recently, there is considerable discussion around systems integration, access, and use. And this is particularly important in corporate campus scenarios where employees may have identification badges or other things which will allow them to make purchases in a food and beverage outlet, or even those cards are often can store value that can then be used to pay for food and beverage offerings. And so there is inevitably some integration that occurs between the F&B operators' point of sale systems and then how those systems may access employee databases or other employer databases within the facility. And so we also typically spend a lot of time talking about how those systems will be integrated, under what circumstances will those systems be accessed and used, and then obviously what is to be done with the information that can be accessed and used. Privacy and data security, like in all commercial transactions, is also something we always talk about as it relates to particularly employee access and access to employees that might be using the F&B facilities. All right. So let's just talk a little bit about the financial models. And for those of you in this industry and have worked in this industry, you recognize that there are a multitude of different models that are called upon and used in these scenarios. They often depend on the type of facility. They often depend on the anticipated user group, whether it's an outside customer or patron that might be using the facility, or whether in fact it's an internal type facility, imagine a university or a corporate campus. I've thrown up here 3 different topics that we typically talk about in many of these. These are by no means exhaustive. One scenario calls for just a traditional management fee to be paid, in which case the owner of the facility typically owns the P&L. All revenues, operating expenses, et cetera, are those of the owner of the facility. And the owner simply pays the operator a management fee. That management fee can be described in many different ways. It can be calculated in many different ways. Rarely do we see any type of incentive type fees paid, simply because many times there's not an expectation that these facilities will generate profits. But management fees can be expressed as overhead expenses, a G&A expense, reimbursements. Many times there are margins and markups on the products that are provided to the F&B operation, which also provides an opportunity for additional compensation to be earned. The second model that we see frequently, and these are typically in facilities where there is some expectation that there in fact will be some profit and revenue generation after the expenses are covered. And in this instance, many times the F&B operator will own the P&L. All revenues, for example, may be collected and kept by the operator. Expenses are those of the operator. And then the revenue, or excuse me, the profit that is then left after the given period, that is shared in some way between the owner of the facility and the operator. In some instances, there can be incentives here based on the amount of revenue and the percentage that is shared, with the percentage going up for the operator as more and more revenues are generated. The third item, which is somewhat unique to this food and beverage context, and this traditionally applies only in circumstances where the parties, again, don't necessarily expect the operation to be profitable on its own. So you may imagine universities or corporate campuses in particular, where I see this most often, is this notion of subsidies And that can occur in many different forms, whether it be in the actual menu pricing, recognizing that they're discounted, and in exchange, there will be an amount paid by the corporate owner to subsidize those amounts, or in the form of a P&L type subsidy, which at the end of the year, if there is a deficit or net operating loss, that the owner of the facility will be obligated to cover that loss. Again, as I said at the outset, there are a multitude of financial models that come into play here. In some instances, I've seen all three of these ideas used in the same agreement. As I said in the previous slide, this is also one area where I will often, particularly when representing owners of these facilities, will bring in an F&B consultant who is more familiar with a food and beverage operation P&L than I am, and will work with us through appropriate margins and appropriate expectations on profits and revenues, in trying to determine appropriate levels of management fee, revenue share, and any subsidies. So that concludes my initial remarks here about these facilities and operations. Stephen, I welcome an opportunity if you want to talk about any of these items. Happy to try to answer any questions that you might have.
Thanks, Greg. As always, an excellent and cogent presentation. Thank you very much for joining us today. And I do have a couple of questions. We have asked the audience to submit through the chat if they have any, and we'll see what comes. But Greg, initially, I can't help but draw comparisons between hotel management contracts and these types of contracts and a couple of the items that you discussed. So first of all, you mentioned that often the owners in these situations will want to have some input or say so in the key hiring, some key hires. Greg, how do you balance that in not taking that over the line so that when liability does arise, it becomes a joint liability situation? I know you walk that fine line forever with hotel management contracts, and it has to be similar in these contracts. Is that a fair assumption?
Absolutely. Matter of fact, the threat of co-employment liability is sometimes used by the operator to suggest, owner, you're asking for a degree of control that really isn't in your best interest.
Yep.
And typically, these limitations or this opportunity for input and control is traditionally limited to the top one or two individuals in the organization. Many owners don't want any input on sort of the line level staff that are doing most of the work. But if these facilities have a general manager or an operations director, typically they'll want some input and control there. And traditionally, it's the right at least to review any materials. It may include the right to interview. And if I'm on the operator side, I try to limit both the time frame that can occur, and many times will limit the number of candidates that the owner can consider before I, as the operator, can choose the person that I want. This is particularly an issue, as you know, in a tight labor market where we may not have 20 candidates, we may only have 3 or 4. And frankly, if we drag our feet and wait for owner input and review, we may lose a candidate. So I recently have found it very effective to tell owners, you don't want us playing around with candidates here. We need to pick one and go. And many times they'll now understand simply because of the labor issues.
Those are excellent suggestions. I like that, especially the potential leverage that the contracting side can use against the owner to kind of push back against their wishes to have that input. Because
Yeah.
I've often felt that a lot of owners on the hotel side or this side, they just don't connect the dots between exercising that wish and the potential for liability. So we got very helpful suggestions. Okay, well, I want to shift gears to another area that I think we can look to hotel management contracts for insight. And I know you do a lot of work in that space as well. And that's on customer data. A lot of these contract food service companies are collecting a lot of data for meetings and things that might be held on the premises or events. Greg, what are the types of of conversations that go on around who's going to ultimately own that data, because we all know how valuable that customer data is today.
Yeah, great question. So I think it's helpful to draw a contrast to a hotel scenario where in a hotel context, not only does the owner want access and use of that guest data, but so does the operator. And many times, if it's a franchise operation, the franchisor, and all of them have, depending on your perspective, legitimate business reasons for wanting that access and expecting to have that access. I work with a number of operators out there that operate both hotels and F&B type operation and facilities. And what I have seen is that in the F&B context, there is a much greater willingness to say to the owner, no, this isn't a patron or guest coming in off the street that may frankly be coming because I'm here. We recognize that this is sort of a closed environment where it could be university students or corporate employees or that scenario. In that case, the operator many times will give ownership and control of that information, allowing the owner to retain that. If I'm in a sports venue where it's a commercial operation and I'm having customers cannot come in off the street, it's probably more like the hotel scenario. But particularly in universities and corporate campuses, most of that information is going to be retained by the owner or the university.
Yeah, that I could see some battles gearing up for of those when these contracts are terminated, if it's not spelled out clearly, right? Like some of the suite owners and things like that, and some of the event. Yeah.
Part of the challenge too is that many operators' systems aren't set up to isolate this information by facility. So, if you come into my operation in Nashville and then someone comes into my operation in Portland, many times I will have a system that aggregates all of that data into an aggregate database. Yeah. If you're now saying to me in Portland, we want you to offer all of the services that you do, but we want you to isolate that information in the Portland facility, sometimes that presents some challenges to the IT teams.
Yeah, it's an interesting world, right? Who'd have thought, 25 years ago, how important all this data would be? But oh my gosh, yeah, crazy good. Greg, well, we don't have any questions in the chat, but do you have any final thoughts for the folks listening in?
I don't. I guess what I would say to any food and beverage operators is that, I am finding some really unique opportunities for operators, and I'm seeing them where operators are sort of stepping out their traditional type operations into other places. One area in particular that we've done some work in is in the retail context, where we're seeing retailers now that want not only just to sell their products at a brick and mortar location, put aside online for a moment, but they want to create an experience, right? And so, whether it be Nordstrom opening bars in many of its stores, or, we've represented some higher end recreational equipment companies that when they have their flagship, take an REI, for example, when they have their flagship store, they want to have F&B offerings there in the flagship store for patrons to use while shopping. And so we're seeing a number of F&B operators, even restaurateurs now taking their experience in F&B and combining it in retail, and it's producing some really interesting outlets.
That's fascinating. Another thing that I've heard about is, a lot of these malls are losing their large retail anchors, and there's so much space there, and they have to replace the traffic that retail anchor may have driven before. I'm curious if you've seen this. We're seeing these mall folks reach out to food hall operators and say, hey, this is, we've got, I don't know how many square feet, but we've got a lot. Can you fill this up and draw people to our mall? Are you seeing that as well?
I am. And, those relationships can be complex in that mall owner may reach out to one F&B operator and said, hey, I want you to create a food hall experience for me. Then that F&B operator, depending on their model, they may sometimes go out and subcontract with various different offerings or different concepts And then you got to worry about that relationship. And many times these contracts take the form of a subcontract where pizza company may be hired by F&B operator to come in and take, a small slot in this food hall and produce pizza. But then they've got to live and work with all of the other food and beverage concepts that are all around them. And so sometimes that creates some interesting issues, but we're seeing a lot of instances where people are trying to create these multiple outlet opportunities.
Yeah, it's going to be interesting to hear what Alexis has to say later about, because in some of these situations, we've seen some, strange bedfellows, as they say, right? Because the larger retail groups are doing anything to fill their space, oftentimes with churches, nursery schools, etc. And then that brings in the challenge of, is the spacing requirements and zoning being met for alcohol beverage licensing? And you've got to be so careful today. So it'll be interesting to hear what Alexis has to say about those situations. Greg, as always, a wealth of information. Thank you kindly. Ladies and gentlemen, if you're looking for somebody that really understands your market, look no further than Greg Duff and his team at Foster Garvey. Always a pleasure, Greg. If I can just remind you to stop sharing your screen. And if you need CLE, please hit yes and submit. And now it's absolutely a pleasure for me to introduce Alexis Mason to you this morning. Alexis is an associate at the Gray Robinson Law Firm, primarily based in Florida, with Alexis in the Miami office. Alexis, building on her in-house counsel work at Reef Technology, is now a member of Gray Robinson's nationwide alcohol beverage department. And the greatest compliment I can ever give to an attorney in this space is that they work with Elizabeth DeConte's and are a member of Elizabeth DeConte's team in the Gray Robinson firm. Ladies and gentlemen, we've worked for, 20 years with Gray Robinson and Elizabeth, and she is one of the most, if not the most knowledgeable person in this space. And we've also learned that anybody on her team brings that depth of knowledge as well. We're very fortunate to have Alexis joining us this morning to talk about the alcohol regulatory system. She's going to give us a brief overview of how we ended up where we are today, and then some very specific things that these third-party contractors in food service need to consider. Thank you for joining us, Alexis.
It's my pleasure. Thank you for having me, Stephen. Nice to meet you, everyone. As Stephen said, I'm part of Gray Robinson's alcohol beverage team. I sit in the Miami office. I'm going to go ahead and share my screen so we can start diving into the presentation here. Okay. Is that showing up proper on your end, Stephen? It looks a little funky on mine.
It's just fine. It's showing a little bit of the presenter's view, but if that's okay with you, I think the audience is just fine with it.
Okay, let me see if I could switch that really quick.
There
we go. Awesome. Oh, wait, I'm paused now. Technical difficulties. There we go. Do you see it now, Stephen?
Perfect now. Thank you.
Wonderful. Okay, great. Alcohol regulatory system. So we're going to do, as Stephen mentioned, an overview of the system generally, as well as some background on specific considerations if you're a food contract management company and considering jumping into the alcohol space. So in order to understand the alcohol regulatory system, it's always best to start with just a brief overview of the history of how we got to where we are, as Stephen suggested. So alcohol has always been and remains one of the most controversial and heavily regulated products in the country. So if we look back to the pre-prohibition era, alcohol was blamed for a variety of issues, from absenteeism in the workplace to spousal domestic issues to political corruption. Alcohol was really the one to blame for a lot of societal issues. And so when we ask ourselves, why was that the case? It really comes down to the dynamic between suppliers and retailers that existed at the time. Suppliers for all intents and purposes, were really powerful, big companies with lots of money, and retailers tended to be smaller enterprises with not the same level of funding. So what happened was suppliers started to effectively puppeteer retailers. They put themselves in a position where they would fund retailers either through interest-free loans for their premises, giving them free equipment, funding their advertising efforts, and of course, expected something in return. So retailers in turn were expected to provide the suppliers with a monopoly to either showcase predominantly the supplier's product, or maybe in some instances, retailers were put in a position where in order to carry the supplier's product at all, they had to consume and purchase minimum quantities that were excessive. So what happened? Overconsumption. Retailers were put in a position where they had to push that alcohol along, sell their product, and they ultimately, of course, pushed the downstream consumers to buy more. So needless to say, there was a lot of desire to get rid of alcohol, and that's how we found ourselves in Prohibition, and that's why the 18th Amendment was passed. So the 18th Amendment passes, the sale and supplying of alcohol was outlawed in the US. And so you would think, all right, well, maybe it went away. Of course not. Instead, what happened was that alcohol was produced and sold by people that we did not want to be in the industry. More specifically, it really became a criminal enterprise. And in order to get the product made and sold, it was either being imported from other countries or produced in some under the ground facilities. And the product was often poisonous, leading to deaths in many cases, or just not something that the consumer really had any transparency into what was in it. So eventually, there was a pretty general consensus that Prohibition was a failed social experiment. And then we had the 21st Amendment, which repealed it. So while we were all on board to repeal Prohibition, we wanted to, of course, be sure that there was a more adequate regulatory framework coming out of it. So what happened was there was federal legislation passed, as well as states began passing their own laws. Those laws might have crossover between states and as well as between state and federal regulation, but oftentimes there are quite a few distinctions. So for my purposes and the rest of our team, often the guidance we provide is it depends. It depends on the state in which you sit. It depends on, as Stephen suggested, potential zoning issues if you're in an incorporated municipality, as well as often local issues. For example, the state of Illinois regulates alcohol, and so do its various cities within it. So when we look at what the system is today, if you look at the illustration on the right, it's really split out into 3 tiers. So the top tier is where we have our suppliers. So breweries, wineries, distilleries. The middle tier is where we have distributors and wholesalers, and the lower tier is where we have our retailers. So that varies from hotels, restaurants, grocery stores, bars, you name it, anywhere that you can go and either buy booze and consume it there, or maybe even off premises. So this was all an outcome of Prohibition and repealing Prohibition, right? We wanted to create some separation between the suppliers at the top tier and the retailers at the bottom tier. So that's where our wholesalers come in the middle. And so the idea here is that each of these tiers should function independently so that we don't have control over one by the other. And so the notion, right, this idea that came out of Prohibition and the pre-Prohibition era, which was the idea of what's called a tied house, right, which was the manufacturer effectively tying itself to a retailer and forcing the retailer to act in certain ways. We've tried to eliminate that through our regulatory framework today. So it's great. It provides that separation and that independence, but it often is very complicated as well. So how is this relevant to you? So Greg gave a few great examples of venues and arenas in which food contract management companies might find themselves. So these are a couple more examples that we are often tasked with helping clients with. So at times we'll have food contract management companies come to us and they perhaps service stadiums, perhaps they service communities, chartered clubs, assisted living facilities, or perhaps they're just doing some sort of corporate function where an office such as Google is maybe looking to do a corporate sponsored happy hour in the office premises. So you, as a food contract management company, might be asked by your client, hey, can you provide alcohol service in addition to the existing food and non-alcohol beverage service you're providing? So the question there becomes, is an alcohol license required? The threshold question you always want to ask yourself is, does the food contract management company sell alcoholic beverages? And as I suggested a bit ago, this is going to change depending on the state in which you sit. So I sit in Florida. You'll notice a few of my examples are going to lean towards Florida. So in Florida, for example, you require consideration for a transfer of alcohol to be considered a sale. So really anything of value. So if I were to give someone money for alcohol, that would be considered a sale. By contrast, if you look at Illinois, it has a lot broader definition of a sale of alcohol. In Illinois, you don't need consideration. So any transfer of alcohol with or without the consideration would be a sale. And so once we know we're a sale, we know we need a liquor license. So then we ask ourselves, oh, and here are just some fun examples to consider. So one thing that I have happened to me frequently is when I go to get my nails done, manicure or pedicure, the salon operator will come up to me and offer me a glass of wine. I'm paying for my manicure and pedicure, and I'm receiving a quote unquote free glass of wine or champagne. Is that a sale? Another example would be you attend a pop-up event. The event has a general admissions ticket, but they also are going to be providing free beverage, whether it's beer, alcohol, spirits, beer, wine, or spirits, excuse me. I'm not paying for the alcohol per drink, but I'm paying a general admission ticket. Is that considered a sale? It's going to depend on the state, but oftentimes you will find that these circumstances, which are giving away booze for free, or at least that's what the person who's doing it suspects, would require an alcohol license. So it's very important, even if you think that your serving booze does not trigger a licensure requirement, that you run it by an attorney in your state and make sure that you're really fleshing out all the potential issues under the beverage law there. So what alcohol license type would be required? So let's assume the conduct that you're going to be undertaking based on your client's request will be a type of action that requires a license. So this is going to depend on various different factors. So first off, and maybe the bigger one that I didn't even include on here is, what are you going to be serving, right? Are you going to be serving just beer? Are you going to be serving just wine, just liquor, a combination of the three? That in many cases will affect the type of license you'll need. Otherwise, things to consider: who will be accessing the property and obtaining the alcoholic beverages. So for example, in the state of Florida, we have a liquor license called a club license. This license is not for a nightclub. Think of it as the type of club license that would be given to a country club or potentially a residential community. That license allows the holder to serve liquor to members of the club or their guests. So with that license, a random person off the street could not come into the facility and be served alcohol. Conversely, there could be licenses that require you to accept foot traffic off of the street in order to hold the license. So it's important to think about what's going to be happening on the premises that's seeking licensure before you apply. Another consideration is, when will alcohol service be provided? Depending on various factors, including potential zoning codes, you might be limited in the hours during which you can serve alcohol. Some states, for example, Texas, will provide that if you are serving alcohol, perhaps in a stadium venue or at some other event, you'll have extended hours to serve the product. Another thing to consider: what does their property look like? Some liquor licenses might require their property to be a certain size or have certain physical aspects. So another example, in the state of Florida, the license that's typically held by restaurants here is called a 4COP. And an example of that is an SFS license. That license requires the licensed premises to be at least 2,500 square feet and to have capacity to serve at least 150 people. So when you think about the license you're going to obtain, you really need to do some digging on the state law and potential local law to make sure that you have the physical property that's required for the licensure type. And a final consideration is, how much of the service at the premises will be food versus alcohol. So that license I just mentioned a minute ago, that 4COP SFS license in Florida, actually requires a license holder to obtain at least 51% of its revenue from food and non-alcoholic beverage sales. So depending on what you're seeking to do and what your physical premises look like, the license type you'd obtain would be affected. So the next question that often comes up when we are working with food contract management companies is who will hold the alcohol license? So some states allow food service managers to hold a liquor license for the premises, while others do not. So typically the arrangement that we'll see between our food contract management companies and their downstream clients, if they're going to be providing alcohol service, is a management agreement. Some states explicitly require the applicant for a liquor license to have a leasehold interest or ownership interest in the real property. So because a management agreement is not an exclusive right to occupy the premises, a state might say, oh, that's not sufficient. So what I've done here is I've inserted snippets from 2 different sample applications for retailers. The top snippet is an example from Illinois' retailer application. This is a portion of the application where you specify your, as the applicant's, right to occupy the premises and provide that alcohol beverage service. You'll see here that the third option allows you to provide that you are able to be there through a management agreement, versus the North Carolina example below requires you to include a copy of the lease or rental agreement or a copy of your deed, assuming you're the real property owner, specifying you, the applicant, as the lessee or owner. So what's the practical implication here? If you're a food contract management company and your only right to occupy the premises is under a management arrangement, you might have to work with the premise lessee or lessor to see who's more appropriately suited to obtain the license. So additional considerations that could potentially come up in the licensing process. So generally, every state is going to have some sort of qualification requirement for a licensee. It'll, of course, be typical things. You have to have good moral character. You know, you can't have certain criminal backgrounds. And this all throws us back to what was going on during the Prohibition era, when we had really criminal enterprises running the alcohol industry. And so what you'll find is a lot of the requirements now very clearly tied to what was in place before the requirements came along. So if you're applying for the license as an individual, you would have to undertake those qualification requirements and make any disclosures that are necessary individually. If you're applying through a corporate entity, be it an LLC, a partnership, or a corporation, you will likely have to undertake those qualification requirements and disclose whatever is necessary for your owners potentially, as well as officers and managers. So this tends to be something that comes up quite a bit in our experience. Oftentimes we'll have clients who have set up corporate entities and want to run their operations through the corporate entity and prefer not to have to undergo fingerprinting or a background check individually, or provide some of the intrusive information that some of these applications can require. And so oftentimes you really need to think about what you're going to have to disclose and make sure you're comfortable with that before proceeding. So another item, which we just touched on a bit ago, is your right to occupy the premises. That's a big ticket item when you're a food contract management company, making sure that you're able to hold the liquor license under the state's laws. And again, as Stephen suggested at the outset, zoning requirements. A lot of incorporated municipalities will either have dry counties, wet counties, meaning dry as in you can't serve alcoholic beverages there, and wet meaning you can. There might also be limitations on the type of license you can hold in particular districts within a county. An example of this is Hillsborough County in Florida. There are limitations on what licenses can be held where, and you might have to go through an approval process with the zoning administrator. If you fall outside of what's typically allowed in certain areas, you might need a waiver to be where you want to be. And then another final consideration, and this certainly is not an exhaustive list, is does the state that you're seeking to get a license in have an alcohol server training requirement? So a few states will require the individuals who will be pouring alcohol on the licensed premises to have undergone a training, and they'll have to be able to provide proof, so a certification indicating so at the time that they apply for their license. So what does this mean practically if you're a food contract management company and you are seeking to set up an arrangement whereby you also provide alcoholic beverage services to your clients? So again, the main agreement that would be in place is the management agreement. A lot of states will have very specific regulations and requirements on what can and cannot be in a management agreement. For example, in Florida, we have an administrative code provision that sets forth the specifics of who can control alcohol, who can make purchasing decisions on behalf of the licensee. And in the event that the licensee is not, in fact, the food contract management company, and it's perhaps the owner of the real property, that management agreement is going to be highly regulated under Florida law to make sure it meets the requirements as far as what the food contract management company can do on the licensee's behalf. Additional considerations: oftentimes in the licensure process, you'll have to provide a copy of your management agreement to the relevant regulators. You want to make sure as you're drafting those agreements that any confidentiality provisions in them will not prohibit you from doing so, as well as also considering whether there are any particular sensitive provisions in there that you might not want handed over to a regulator. In the state of Florida, you can provide management agreements to our division here and request that they be marked as confidential, and so they won't be able to be requested via a public records request. But other states might not have that process in line. So you might have to disclose full copies of your management agreement, in which case, if someone does a public records request, whatever's in there would be available to whoever requests a document or a copy of that document. So oftentimes particular fee arrangements, whether they're percentage-based, whether they give commission, that information that you put in a management agreement can affect the level of scrutiny that's given to it as it's reviewed by regulators. And it could also end up in the hands of someone else if there's a record request submitted through the state. Lease arrangements, as we've already touched on, you'll have to really think through what the licensure requirements are in the state and whether or not you are or are not the lessee of the premises and how that could affect your ability to occupy the premises and obtain a license for the alcoholic beverage service on the premises. And then finally, as you think about structuring really your operations on the site, as we discussed in prior slides, what does your license allow you to do? Does a license allow you to accept foot traffic off of the street? Does it allow you to serve particular types of alcohol during particular hours? And of course, if the license is not in fact held by the food contract management company, but it's perhaps held by the property owner or tenant at the site, are you as a food contract management company able to pour alcohol, and are your employees able to do so on behalf of the actual license holder? So these are different things to think through as you consider how you're going to set up your licensure. And then a concluding thought, of course, this is for attorneys and risk counsel and things of that nature. So we always wonder, well, where does the liability lie if there's an error here? So let's entertain a situation in which a food contract management company cannot hold the liquor license because its management agreement isn't sufficient to prove its right to occupy the premises. So maybe the food contract management company will tell its client, who's the tenant, who operates that facility otherwise and is going to obtain the liquor license, that the food contract management company will indemnify the tenant under its management agreement. Is that sufficient? Or that the food management company will provide, liability insurance coverage for the licensee? Is that sufficient? Ultimately, the licensee is going to be liable for operations on the licensed premises. And the idea here is really one of jurisdiction, right? The license holder is subject to the division's jurisdiction. So if there were ever an issue on the premises arising from the sale of alcohol, the regulator in the state that applies will likely go over to that licensee and say, you're on the hook for this. Whether or not the licensee can then go after the food contract management company is really where the analysis hinges, right? So can you be indemnified? Absolutely. But ultimately, the licensee will probably be on the hook and will have to seek that indemnity right. And then, of course, another way to come after someone under these laws is if unlicensed sales of alcohol are going on. So even if you don't have a liquor license and if no one on the premises is licensed, And perhaps you're operating under one of the hypotheticals we discussed before and thinking, oh, I'm giving this away for free. A license isn't required. The unlicensed sale of alcohol is illegal, and it would be an issue that would, attract regulator scrutiny and could put you in a compromising position. So it's always important, regardless of whether you think it's a sale or not, to make sure you seek guidance to confirm that. And that is pretty much it.
Wow, that was great, Alexis. Such insightful information. I've got a couple of questions already. One is I want to focus on this social host concept that you've brought so well to the forefront for everybody to think about. I spend a lot of time on the hotel side, so I'm constantly looking to that for analogy. And we have these large hotel groups, Embassy Suites. I won't mention any names, but their initials are Embassy Suites, right? That they have these general manager happy hours, all the time. And you've brought up the same concept here, right? They always think, well, it's a social host. We don't really need a license because we're not getting that direct consideration. But in your experience, it sounds like that indirect consideration could definitely be used to potentially hold them liable. And I guess what I'm asking you is, in your experience, it comes down to what is a sale. Is that a fair?
I think that's a fair assessment, Stephen. That's always where we start our analysis. Oftentimes we get these fact patterns and we start jumping through the hoops and thinking all these things through. And then we say, well, hold on a minute. Was there even a sale here? So that's always the first question is there a sale? And you'd be amazed how much it can vary depending on state law. I was blown away by Illinois law when I saw that any transfer of alcohol would really capture that.
Well, that clears it up pretty quickly, doesn't it? When it does that. And it really, I was thinking when you were going through this takes us back to like law school 101, right? And consideration, and what does that mean in value, and can it be direct or indirected? That was just a very interesting thing. But the example you gave from Illinois, I was like, oh, wow. I doubt many operators really know that.
I completely agree.
Well, I'll put it this way. It was a surprise to you guys. It was a surprise to everybody else in the world. I can promise you that. Okay, I have another question that's I think is going to be an interesting question. And that is, Alexis, a lot of places today operate in these venues or jurisdictions that do require this 51% of revenue sales to be food, right? In order to get a liquor license and in order to sustain the right to have the liquor, or privilege to have the liquor license. Okay. So now though, we have this enormous amount of our revenue coming from Uber Eats or other food delivery systems, and they're taking 13, 14, whatever the percent is off the top of my sales number. Has anybody in your experience been challenged by the jurisdiction because, oh no, your food revenue is not as high as it needs to be? And then the operator says, but wait, it is, we're just having to share it with the operator, but on their books, they're not getting credit for that much. Has that popped up in any conversations? Have I explained that well enough to even you see a question there?
You certainly have, Stephen. I'm following you perfectly well. To be quite frank, that hasn't come up for me yet. What we generally tell clients to make sure that they're protected in the event that that percentage is ever questioned is to really keep very stringent records. Because what will generally happen is if your license is up for renewal, if there's ever a question that you have this, for example, in Florida, that 4COP SFS license, but that's typically a restaurant license and it looks like you're operating a club here. It's really important to maintain those clear records to make sure that you have that percentage requirement met. I've never seen that issue arise previously. What we've seen mostly in the Uber Eats and food and app delivery space is more so questions of whether or not alcohol can be delivered and ID requirements. And now with the pandemic, we've seen so much legislation around cocktails to go and whether or not that can be facilitated through apps. So it's been really impressive. It's funny you bring up Uber Eats because that's been a big part of our practice, I would say, in the past year or so, is really focusing on that sector.
Yeah, I think one of your colleagues visited with our audience about that at one of our previous conferences, and it was just fascinating. And it reminds us, we also have, when we talk on the food side and the beverage side, of course, when you have a gross percentage lease situation, and a lot of operators get clobbered because in the lease agreement it doesn't clearly identify that those fees you're paying to the food delivery mechanism do not get counted, in towards your revenue. But I could see where that might, if you're in this 51% space, where you might need that right to count. I don't know. I'm a professor, so I think way too much about these things, and perhaps we should edit this out so no enterprising jurisdiction goes, hey, what about this? I've got one other question to ask you, Alexis, and that's on the indemnification side. It seems to me, I haven't seen the specialization for lawyers yet in just indemnification contracts, certainly in insurance and risk. I get that. But you raised such a good point of, even with that indemnification, in your experience, they're not, the licensee is not going to wiggle out of this, right? As typical indemnification, you're going to get sued and then you're going to have to seek that, which demonstrates to all of us how important the crafting of that indemnification clause is. And most importantly, in my experience, how good the insurance is behind that indemnification. I'm assuming you guys have seen that in your practice as well.
Yeah, absolutely. You nailed it on the head there, Stephen. Indemnity is massive for us.
Yeah.
And it is often a twofold analysis, because of course the counterparty to the agreement says, great, you're going to indemnify me, but if you're insolvent, if you can't back up the lawsuit, what good is that for me? I'm still
That's
on the
right.
hook. So insurance coverage is certainly a critical second aspect that we have to make sure we account for properly to get the other side to the agreement comfortable with the arrangement and the risk, if any.
Absolutely. That comfort level, I don't know how you make that happen, but it's got to be a big part of what you guys deliver for sure.
Absolutely.
Well, Alexis, I don't think we've seen any question in the chat, but listen, thank you so much for joining us today. Do you have any final thoughts you'd like to share?
I guess the recurring thought in all of this, which I think was clear in my presentation, is that alcohol is a tricky area of the law. It is very archaic in a lot of its rulemaking, and it's very easy to run afoul of it if you don't have proper counsel on it. It is different everywhere you look. I've worked on different transactions this year with different wholesalers and states that vary. And I'm blown away every day by the things that I find in the beverage laws. So just anytime these issues come up, regardless of what you think and whether you think it is or is not a sale, always get a second opinion on that.
I think that's great guidance. Thank you. And my final thoughts are, listen, if you're looking for a law firm across the country that can assist you in understanding all of these nuances in licensing, in sales, and potential for liability, look no further than Gray Robinson and the absolute outstanding team that they have assembled there. And the other thing they do that I want to be sure and mention is that if you are doing M&As or mergers and acquisitions, or you guys are buying things, this is the firm that has done the small ones to the enormous transfers of licenses. And so you would be in great hands there too. Alexis, thank you again. We look forward to having you back soon.
It was my pleasure. Thank you, Stephen. I look forward to it.
That sounds great. Thank you. Okay, guys, well, we're going to do one more CLE quick survey. So hit that yes button. If it's important to you, hit the submit button. And I'd like to take this opportunity to thank all of our speakers, Justin, Greg, and Alexis. I told you at the beginning, they were the thought leaders in their respective spaces, and they demonstrated and validated that. Wow, great information. Thanks to everybody for joining us. It's been a wonderful hour and a half. We hope you enjoyed it and walked away with some helpful information for your operations going forward. We hope to see you in the future. Thanks again for joining us. From all of us at HospitalityLawyer.com, Thank you and stay healthy.